Hello friends, welcome to my episode Property Decoder. Today we are going to discuss a very important judgment by Supreme Court, Shanti Devi versus Jagan Devi and others. It's a civil appeal number 11795 of 2025. Judgment by Supreme Court decided on 12th September 2025 by Justice J.B. Pardiwala and Justice R. Mahadevan. Now, this case revolves around a dispute sale executed in 1973 concerning agricultural land in village Bisar, Akbarpur, Gurgaon. The plaintiff, who were claiming one-third ownership, alleged that the defendant had got a fraudulent sale deed registered in her favor. They argued that the deed was not executed by them, no sale consideration was paid, and the document itself was a sham. On this basis, they sought either protection of their possession or joint possession of the land. Now, the defendant's stand was completely opposite. She contended that the plaintiff had indeed executed the deed, had accepted the consideration of 15,000, and voluntarily appeared before the sub-registrar office for registration of the sale deed. She further argued that the plaintiff were stopped from denying the transaction and that the suit was hopeless, barred by the limitation since it was filed after more than 11 years, holding that the sale deed was fraudulent, void, and without consideration. Now, according to Article 65 of the Limitation Act, applied giving 12 years to challenge, and thus the suit filed in 1984 was within the limitation. The High Court upheld the decree, although it cited Article 59 instead of Article 65, yet ruled the suit within the limitation. Now, before Supreme Court, the appellant defendant argued strongly that the suit was barred by limitation under Article 59 and or 56 since it was filed after more than 3 years from the execution of the deed. Now, second point was a registered sale deed carries a presumption of validity and the burden was on the plaintiff to disapprove it or to disprove it. Now, third point was the plaintiff had failed to lead the conclusive evidence of fraud and hence the deed could not be brushed aside as a nullity. On the other hand, the respondent plaintiff submitted that the deed was void ab initio since the plaintiff never executed it, her thumb impression was not on the deed. The second point which they raised is that the no sale consideration was paid, which under Section 54 of the Transfer Property Act makes the transaction null and void. Third point, when a document is void, Article 65 applies, giving 12 years to seek the petition. They cited landmark cases like Prem Singh versus Birbal and State of Maharashtra versus Praveen Kamdar, stressing that no cancellation is required of a void instrument. The Supreme Court's analysis was extremely detailed. They have done a detailed analysis for this judgment. It distinguished between void and voidable documents. If a deed is voidable, for example due to coercion or misrepresentation of the fact, the Article 59 applies within a 3 years of limitation. But if it is void ab initio, like when the executor never signed or no consideration was paid, then Article 65 applies, giving 12 years. Now here, concurrent finding of the First Appellate Court and the High Court showed that the plaintiff had never put her thumb impression on the deed. No sale consideration was ever proved. Attesting witnesses were either dead, related to the defendant, or unreliable. The defendant's husband, who allegedly paid the consideration, never entered the witness box. Therefore, the court held that the sale deed was void ab initio, not merely voidable. Since the suit was filed within 11 years of execution, it was well within limitation under Article 65. Ultimately, Supreme Court dismissed the appeal, affirming that the plaintiff's suit was maintainable. However, it corrected the High Court reasoning, clarifying that the Article 65, which applied 12 years of limitation, applies not Article 59, that is 3 years of limitation, when dealing with the void document. This judgment is important because it reiterates a critical principle. If a sale deed is void ab initio, the aggrieved party need not seek any cancellation of the deed. They can directly sue for the possession within 12 years. Only if the deed is voidable, cancellation within 3 years is mandatory. So friends, this case is a strong reminder of how the distinction between the void and voidable documents shapes the limitation period and an entire litigation strategy. That's all for today. Myself Anil Diwan, the founder of One Square Feet. Thank you.